is that the concept of jury nullification should be allowed as an affirmative defense. Right now, jurors are allowed to apply laws in a lot of states and in a lot of districts. But essentially what happens is that lawyers are not allowed to close an affirmative defense. They're not allowed to give arguments that either the law in question or the application of that law is actually justified or unjustified, as the case may be. So what we're going to say on our side of the house is that lawyers should be able to say not guilty by reason of jury, by reason of nullification, by reason of justice or something like that, or however you want to tell or something. But that's essentially happening. So the 3 reasons for why we think this is a stellar idea. The first thing we want to talk about is nullification and why it's a good idea. Please recognize right now that nullification exists. Even in places where nullification doesn't actually exist for jurors as a right, jurors, we believe, should have a right to this. And even if they don't, it's going to happen anyway. Like, even if a jury believes that this person actually committed a certain law, if that jury actually believes that the law is essentially unjustified, let's not fool ourselves. That jury is going to acquit that person. That jury is going to say, well, there's inconclusive evidence. Well, we just didn't, we found people down. That's what happens. We think it's important to have some transparency in society. We believe it's important for society to know what individuals think about the rule of law. But more importantly, we think that there are just instances of when a law is unjust. When a person steals a loaf of bread so that they're starving family, we would actually believe that that's a legitimate exercise of jury nullification if the jury so believes that. But additionally, recognize that some laws only exist or are only enforced because they're unequally enforced, right? Like there are some laws that are only enforced against a certain aspect of or a certain group in society. Recreational drug laws are only enforced against a certain group in society. Sodomy laws are only enforced against a certain group in society. We don't think that it's fair to have laws on the books that are only there. And if they were enforced to all of society, society would clearly disagree with those laws. But the only reason that society does agree with those laws in the status quo is because of the fact that they're put on black people, or because they're put on young people, or because they're put on individuals because they're poor. That's not right. That's not something that should happen in a liberal democracy. But you disagree.
Won't the appeals process, eventually challenging things through the Court of Appeals and then the Supreme Court, isn't that a way to get rid of law?
Because I want to ask you a question. How long does it take to get a law taken off the books? How long does it take to get a written on the court? How long does it take that somebody, has to wait in jail because the law is unjust? That's not fair. It's not fair for us to say, well, you're going to be the pawn in this legalization game because we didn't want to take upon ourselves the drastic measures. We don't think that it's fair to put somebody behind bars for 10 or 12 years, which is oftentimes the length of an appeals process because of the fact that we didn't want to take certain steps when we should. But additionally, thank you, recognize that it's a good idea to transfer a judge's power. Recognize that if we were to allow for a bench trial and judges would be the ones who would be the actual ones making the decisions, nullification in that sense would be correct. But we also believe that juries, in a sense, when they make a decision about the defendant, are taking a transferal of the judge's powers. At that point, if the judge is allowed to nullify a law, we think that this individual should as well. But finally, we want to talk about the idea of transparency under this idea of nullification. Because it's going to happen anyways. But the problem is that the people who know about nullification, the people who know about it, because they're not going to be able to be told about it in the court of law, those people are the educated people. Those people are overwhelmingly the richer segment of society. So when you have somebody committing a law in Westchester versus committing a violation of the law in Crown Heights, the person in Crown Heights isn't going to be able to get a jury of his peers who knows about jury nullification, and then he's going to be convicted of an unjust law. But the guy in Scarsdale, the guy in Westchester, no thank you, he's going to be able to get off because those people actually know about jury nullification, because those people actually know what the laws are, and we think that's unfair. We don't think it's fair to only allow certain individuals in society the ability to exercise a right because of the fact that they come from a more privileged background. The second thing we want to talk about, however,
sure. You really think that 12 random black people in Brooklyn who, as you claim, who were recipients of all this unjust treatment by the police, would never think to nullify if they hadn't been told they could do it?
No. The fact is, if you want to take 12 people in Crown Heights versus 12 people in Scarsdale, I bet you $10 there's going to be people in Scarsdale who are an overwhelming majority are the ones who actually know the law can be nullified. That doesn't happen in the status quo. That's false. The second thing we want to talk about is citizens and democracy. Look, right now we believe that jury nullification is a form of civil disobedience. There are certain laws that are constitutional. There are certain laws that are wrong. Segregation laws were constitutional, but individuals sometimes have an obligation to follow those laws. And you think that if I, as an individual, in my day-to-day life, were going to violate a law because I believe that I should, because of civil disobedience, it is hypocritical of me to then sentence somebody else because I'm in a jury box for committing that same infraction of the law, right? We see things that segregational laws are unconstitutional. The fact that you do punish differently for crack cocaine violations, those things, are also examples of the fact that the formation of the rule of law is not representation. Look, we like to believe that we live in a representative democracy, but it's just not true sometimes. The fact is that we have really no check on the formation of the rule of law, but we think that individuals in society should be able to have some type of relevant check, and this is what gives those citizens that right. Especially when somebody's life is on the line, especially when somebody's liberty is on the line. That's when society has to take upon itself this greatest check upon the government. The right is one of the problems is that even if I believe that law is unjust, even if all of society believes the law is unjust, it doesn't matter, because it's going to take a few years for us to actually get that law. We're going to have to elect representatives, we're going to have to elect senators who also believe in our ideology. We're going to have to get that through Congress, and that's going to take a few years. And in those few years, there are going to be a whole lot of people who are going to have to be sent off to jail because of an unjust law. And they might want to defend appealing, they might want to defend going to the Supreme Court. They can do that, and they can run with that argument. It's not a very good one, because it's just going to take a whole lot of time that these people don't have. And they shouldn't be realized that we're using it to lead to our own subjective ends. But finally, I want to talk under this idea of citizens and democracy, the idea of the fact that it's important for society to know about the aspects of the rule of law. In a large group in society, if society believes that a law is essentially unjustified, we should know about it. We should know that when the jury says no, not guilty by reason of nullification, then we actually have a signal to government, a message to government saying, we in society believe that this law is unjustified, or that this said application of the law is unjustified. But the final thing we want to talk about is fair trial. Because if the process is perfect, some laws wouldn't exist. But recognize right now the process isn't perfect, and so those laws still do exist. But in the meantime, not fair to punish. Additionally, because of retroactive, because a lot of the problems are retroactive, if a law 10 years down the road gets deemed unconstitutional, those people in 10 years necessarily don't get 10 years back of liberty. That's not fair. Finally, however, is the idea of an accurate defense and better options. Look, people should have a right to argue what they want for their defendants. Lawyers should have as many options as they can. We don't get that when you don't have jury nullification as an affirmative defense. But additionally, jurors are not going to buy it if it's a stupid nullification defense. It's not like jurors are going to be like, oh, he really wanted that stereo, so I guess laws against burglary obviously shouldn't be nullified. We recognize that jurors, individuals, are at a last chance to actually decide to do this by reason of nullification, because if they do, they're going to actually have to admit their guilt for violating this law in the first place. They're not going to want to do that, so it won't happen all the time beside opposition. Look, courts are supposed to be truth-finding, so courts are supposed to be fact-finding. If we actually believe that's the case, if we actually believe justice as a means to a greater end, then we have to believe in jury nullification as a affirmative defense. We proudly proclaim this.
Thank you, Mr. Marks, and call upon the leader of the opposition, Mr. Cox, to state his speech.
Thank you, Mr. Speaker. It's a tremendous honor to be here. I have 4 independent points. The first thing I want to talk about is the problem of having a small minority, specifically a minority of 12 people, overriding a law that was enacted by an entire democracy. Because we think the fundamental part of living in a democracy, rather than living in a dictatorship, or a system in which one person can decide what the law is that the law represents some manifestation of the collective will. A lot of people in this room may not like drug laws, but that doesn't change the fact that more than 50% of the people in the country voted for those drug laws and decided democratically that they ought to exist. We think you're just making a sham of democracy at the point where you say that any randomly selected 12 people can decide what the law is. In principle, that contradicts the fundamental notion of how democracy ought to operate. No thank you. The second thing I want to talk about is a way to solve for actual cases of unjust application of law. I think the appeals process is a fantastic way to do it. Why? Because when you go through the appeals process, you get 2 significant benefits. First of all, you actually get laws struck down rather than just not applying to a case. Because a major problem with jury nullification is that it just doesn't have the law applied in one particular case, but that law remains on the books. And if that law really is unjust, it remains having all those bad facts. Only people don't actually know about it, because people aren't actually getting punished for it because the jury nullifies individual cases. But the appeals process also means that people actually know what the law is. Judges are making these decisions rather than random people off the street who might not know the context of how a law is being applied, might not have the legal background knowledge necessary to make those decisions. Sure.
Then why do we trust them to put somebody in jail if they don't understand the law?
Which we think, in general, what juries are supposed to do is to find facts and really go through the job of analyzing facts and do so as objectively as possible. They're not supposed to know what the law is. The lawyers are supposed to explain the context of what the law is to them. Here they're saying you have to interpret the context of the law. Jurors don't do that. The third independent we think a very important feature of good law is the ability to know what that law is. We think it's essentially a major problem for society. People are going around not knowing whether what they're doing is illegal. We think that necessarily happens on the inside of the house. A split or nullification is an affirmative defense. When someone can just commit a crime, yet expect to get off, thinking, well, this may be illegal technically, but it ought not be illegal, therefore, I'm not actually committing a crime. We think the only way that the law can have real power is if that law is knowable, that law is concrete, and that law is applied equally across all cases. Different groups of 12 people are going to make different decisions. That means the same law is necessarily going to get nullified in some cases, but not in others, and that unequal application of the law is making a sham of the justice system. But the fourth and last independent thing I want to talk about is the idea of helping poor defendants and the importance of lawyers in the courtroom. Which they say they want to open up more defendants, the most defendants possible, the better. We think the more kinds of primarily rhetorical defenses we make available to lawyers, the more lawyers matter. We think a good lawyer is always going to be able to come up with some reason why nullification is the code. We think those lawyers will provide even more of an advantage than they do in the status quo to the people who can afford to pay for those good lawyers. I think the last thing our justice system needs is something else that's advantaging the rich at the expense of the poor, and I don't think that's a good thing to incorporate in the system. An added harm in terms of this kind of problem of lawyers making these kinds of arguments is that every case in this situation is probably going to go to trial, or at least a lot more cases are going to go to trial. Because even if someone is obviously guilty, their lawyer will take the time to take it to trial, take the time to try to make the nullification argument, just in case someone buys it. Another thing our legal system really doesn't need is a whole bunch more cases clogging up that system, especially when they're cases of someone who clearly violated the letter of the law, and we're going to respect that letter at all, deserves to go to trial. Let's look at the case. The first thing they talk about is the concept of nullification. And they say jurors will nullify it. First of all, I don't think we want jurors to nullify. We want to encourage jurors. I think society would be better, for all the reasons I've already outlined, if jurors didn't nullify. And we shouldn't incorporate elements into the system if we don't want jurors to act on them. Even if they're going to do it anyway, we don't want to codify that they should do it by saying, go ahead and make arguments about nullification, go ahead and nullify. We also think there are plenty of laws we put into society just to set standards. Laws like saying there shouldn't be begging on the subway, even if we don't ever enforce those laws, are nevertheless there because we believe those laws are setting some kind of important standard for society. We think saying we don't want jury nullification sets that standard. Then they talk about laws being unequally enforced, like recreation codes. The first thing I would say is if you're going to talk about unequal enforcement, the most unequal enforcement comes when a different group of randomly selected 12 people is going to make a vastly different decision because they just consider their own subjective judgment about whether or not they think a law is good and deciding whether to apply that law. Jurors shouldn't have that kind of discretion. But also, with the example that provides recreation laws, they say laws against recreation drugs are enforced disparately in, say, the Bronx versus Manhattan. What we tell you is a jury certainly isn't going to know the context of how a law is enforced. A jury just knows what's going on in their community. Jurors are drawn from these local communities. We think as a result, if anyone's qualified to make these contextual determinations, it has to be judges and it has to be done through the rigorous process. Jurors just aren't qualified. They say appeals take appeals. Appeals are the only way to actually change law, to actually make sure that laws don't remain on the books, don't remain applied unjustly in the long run. So appeals may take a long time, but that's a price we're willing to bear on our side. The next thing they talk about is transferring power from judges. We don't really think judges ought to be able to just decide to nullify a law at lower courts either. We think that's what the appeals process is for. We think judges should be able to decide if the law was applied in the framework of the law, but not to make these extra contextual decisions about whether or not the law itself is just. But moreover, we think a judge knows what the law is, and that's extremely important in deciding whether a law was applied correctly. Juries don't have that knowledge. They say only educated people know about nullification or voting nullify. I think the exact opposite is true. I think, in fact, educated people are more likely to know that in the status quo, they're not supposed to nullify, they're not supposed to listen to arguments about nullification, and won't do that. A random person on a jury who doesn't know anything about the law won't know what nullification is, but they'll still say, hey, I don't think that guy is justly convicted, and they'll acquit him anyway, even without knowing the specific legal reasons for this.
A lot of arguments individual society and not about that society itself.
The problem is, I don't think a legal system can ever function just treating each individual case differently. And the one where you just try to treat each individual case as an individual case and say, this person did exactly the same thing as this other person, but because we're going to treat them as an individual, we're going to punish them in an entirely different way. I don't think that society is functioning here. The second thing they talk about is citizens and democracy. They say it's quite critical to sentence someone for something that you don't believe. I think there's an obligation for democracy to work for society first, even if working for society is going against your own personal values. You can engage in civil disobedience and try to change the law, but that doesn't mean you don't have to follow the law, while the law still is what the law is. You can't just ignore the laws because you don't like them, even while you're willing to change them. And they say the formation of law isn't representative. What? We vote for the legislature. I think there are significant democratic checks for our society. You may not like the way they're applied, but I think they still end up with majoritarian outcomes, generally democratic outcomes, a whole lot more democratic outcomes than you're going to end up with just 12 randomly selected people are making these kinds of significant decisions. They say it's going to take time to change these things. Most people do not agree on what the law should be. At that point, as long as most people like progress, or most people might not share the opinions of these subjective jurors, they think it's a whole lot worse to just have the law unselectively applied, and applied in ways that aren't going to lead to just outcomes. They say, in this case, we know that society thinks the law is unjustified. A jury doesn't have to explain its decision, therefore society isn't going to get that message. There are other methods of protesting, but moreover, in most of these cases, all of society isn't going to think that law is unjustified. The last thing they talk about then, sort of in the middle of race, is fair laws. And they say, well, you're going to lose 10 years of your life in that. I've already explained why this time element is just a necessary sacrifice to go. They say it's better for lawyers to have options. Giving lawyers more options just makes it easier for rich lawyers to get guilty people. The last thing they tell you is, well, a jury just isn't going to buy stupid defense. I think this is giving way too much confidence in individual juries. I think a random selection of 12 people is going to buy plenty of stupid defenses, especially if they're made in very rhetorical fashion by Johnny Cochran or some other highly paid lawyer who's just being put up there to get a rich, guilty person off. We don't think that person should get off.
Thank you, Jay, for his remarks and call upon the member of the government after the U.S.
I think I'm actually with Jay in this whole not thinking too much. So I'm just going to bluntly take everyone, say everything with your and I hope you know. So the first point we get from Jay is that this is essentially an unjust instance of a minority of individuals deciding that they're not going to override a law with society. And I want to talk about that concept of common law and like why in America and like in sort of the Western world we have such a hard on for like having like the right to be tried by, you know, a group of your peers. And essentially we believe that it's not like the government just out there sort of logically like imposing these laws upon society, but rather that in general the law ought to follow along with what we believe to be just and what we believe to be in line with the rules of our society. And essentially why you have the right to be tried by like a group of your peers is that they know they're sort of a representative group of society who knows what society believes to be just in particular instances for thinking. And because they know that, they have the right to decide whether in this instance the law is appropriate, to what extent you ought to be forced to it's good to keep the law. Like, we wouldn't want to completely do away with the law against theft. But we would recognize, and think that in certain instances it would be unjust to apply to individuals the law against theft, like in the example I gave you. There might also be other laws that are unjust in segregation, but that sort of meet the criteria for being constitutional and not being overturned by the courts. In those instances, the laws might not get, through the appeals process, taken off the books. So thank you. But at the same time, we recognize that they're unjust laws which ought not to apply to individuals in society. The last thing I want to tell you, which is what Neil tells you, is that it takes a long time to get an unjust law. So, for instance, like, in our society, like, the penalty for possessing crack cocaine is, like, much greater than the penalty for, like, just possessing coke. And we think it's wrong that, like, some black person is going to, like, get stuck in jail for 50 years for having possessed crack. We think that's an unjust sentence. And it's wrong to say, well, you poor person who got sort of fell through the cracks, got stuck, are going to have to be in jail for 50 years for possessing crack while we wait to get this unjust law removed from the books. And finally, sort of under this point, we get the idea that judges, like, know the law better than the jury, and therefore, like, they have the right to say nullify, but the jury doesn't. We disagree. We think, like, if we believe in American society that jurors, like, have a right to participate in deciding, like, whether or not an individual is guilty, they can decide, like, whether or not, like, the evidence meets the reasonable doubt standard. We think they can also decide, like, whether or not, like, this situation meets the unjust law standard. I don't see how it's, like, significant. Next, we get the idea that it's important to know beforehand, like, what the laws are. But look, as Neil tells you in his first point on the case, individuals already, like, serving on juries already use, like, the nullification standard. They already can decide, I think this law is unjust, so I'm not going to convict the person. No, thank you. At that point, the law is already there. It's already being applied against individuals. They're simply not aware that it can be used against them. And because, like, lawyers in the courtroom are not allowed to either make or defend against things like nullifications, at that point, individuals can't even, like, have the prosecutor saying, jury, don't nullify. Essentially, like, we're having the process going on already, but we don't have the transparency. We don't have individuals knowing what the laws are. So actually, the hurt is greater on their side. We're simply making it something that individuals can know against, know about, and and use in their own defense. And finally, we get the idea that, like, lawyers are suddenly going to become, like, a great deal more important. Honestly, I don't really see how lawyers could get any more important than jurists. And, like, in fact, I think we're just giving them a fair defense. Because in some instances, like, it's clear that an individual did it. Like, there's overwhelming evidence that, in fact, they did commit this crime. But at the same time, like, the reason they committed the crime was because they believed the law to be unjust. No, thank you. I think it's unfair to not allow them to make the argument that it would be wrong to convict me of this crime, like, because I committed it, believing that, like, segregation is wrong, or, like, laws against marijuana are wrong, and, like, I exercised my right to, like, disobey the law, which, like, is bad. At the same time, like, you get the idea that, like, more cases are going to go to trial. Like, if we can all, sitting in this room, hear, like, a 30-second example, like, if I go, like, beat up an old lady for her welfare check, and then, like, try to use the nullification evidence, that's stupid. Everyone in the room agrees that this is stupid. And a jury would also believe that this is stupid, and would simply, like, not buy the nullification evidence. There's no incentive, for an individual to take the risk of, like, beating up that old lady and getting caught, just because they might be able to, like, possibly get some of the as like wealthier people in society. Unfortunately, like we don't live in a perfect society. We have laws that are often unjust, and we need to be able to do something to correct it. And so that sort of ties into the last thing we talked about, which is that like the legal system necessarily screws up sometimes. We need to be able to like correct that. And the only response we get is, well, it's easier for rich people to be able to get a lawyer who will get the law. Like that's true, but I don't think it's wrong to deny to poor people like the right to make the defense that they broke the law because it wasn't unjust. We need to have that right.
Thank the member for her remarks and call on the member of opposition, Ms. Tim Willenken.
I'm going to begin where JD about the concept of 12 people substituting their decision for the decision reached legally by the majority of people. And I think we're very lucky to be on APDA, where Maryland is considered the South. Because in fact, our country goes far further south than the genteel state of Maryland. And I'm not going to use the hackneyed example of lynching. I'm going to talk about a very realistic example that's like still alive in our country today. I want to talk about the violence against women. Because the federal government at some point decided that it's a huge problem that in a lot of the less progressive states in our country, people just didn't consider domestic violence to be a very big deal. People sort of thought it was okay in a lot of parts of this country that really aren't as advanced, I would say, as this part of the country. It was like okay to hit your wife with your upper lip. So the federal government has a federal law trying to enforce it. Now, Kate stands up here and talks about how these people who are on your jury know the mores of the community. I think that's true, but I think there's some instances in which the law has to trump the mores of the community. It can only protect unpopular minorities if the law can trump the mores of the community. They say the mores of the community should trump the law. That means you don't get the Violence Against Women Act. That means that women that live in parts of the country where it's considered okay to beat your wife, where women are considered such a form of property, simply have no protection under the law. I am simply not willing to accept that. I am simply not willing to accept that 12 men, because they were taught that women aren't the same as men, should be able to not protect women because they don't want to. Sure.
Tim, why wouldn't those 12 rednecks just find the person not guilty anyways and just not reveal to society that they have the law to be unjust?
Okay, so obviously jury nullification can happen on both sides, but your entire case is premised on the fact that you're often going to argue. You can say that on either side. You say, why can't 12 people find, the sodomist or the crack dealer method either way? I think if we're going to talk about this case in a meaningful way, we should assume that there's impact. There'll be more jury nullification on your side, and there's some disagreement. So I think ultimately, they try to sort of pervert this around, one of the oldest debate tricks in the world, which is focusing on liberal laws that we all think are bad. What about sodomy? What about drinking? Most laws are good. Most laws exist to protect people. Especially, I think most laws that disagree with community mores exist because the federal government thinks it's important to protect minorities that are unpopular in that area. So the second thing I want to talk about is just the notion that Jay talked about is the idea that there's other ways to solve for misapplication. First of all, one thing I think Jay points out is that jury nullification is a band-aid solution. Maybe every so often somebody who suffers from a misapplication gets let off. But the vast majority of people who suffer from some misapplied law will probably still go to jail. If an appeals court, however, looks at this, says there's broad misapplication. If the Department of Justice, which actually has access to the statistics as to how the laws are enforced, which a jury doesn't have, by the way, if they decide that there's a misapplication, they don't just solve it in one case. They can strike down the law, right? They can change the law. They can actually make sure that everybody is helped under this. Because, 1 in 10 people who are prosecuted under unjust law get help on their side of the house. When the Department of Justice, when the federal appeals court decides something, everybody gets help on our side of the house. I think that's a lot more important. But again, moreover, a jury simply doesn't have access to the right information. They don't have access to the application statistics. Moreover, we think that just misapplication of the law is a legal question. When they talk about this I was started thing, as Jay brings up, there's duress, a sort of factual question within the law that juries are allowed to decide on. We think the question of how laws apply involves the wording of the law, its context within other laws. These are simply legal questions that judges are to decide, not factual questions which juries should decide. So then they bring up the segregation example. So I guess the gloves are coming off, right? We're talking about the South in the 1950s. I want to ask you, which side of the house black people in the South in the 1950s are better off? Because there aren't that many black people in juries in the South in the 1950s. So juries can choose to enforce the law when they want to, and choose not to enforce the law when they want to. Guess on which side no lyncher is ever going to go to jail? This side of the house. Ultimately, the only fair application of the law is there isn't this nullification. If there's unpopular minorities, it's much worse for them. So the third thing we talk about is makes the law known, right? In general, we think you should be able to look at the law, but find out what the law is, know the community standards, right? So like, I'm going to Nevada and I want to know if like XYZ law is like actually the case. I can't just look at the law books, right? I have to like poll people in Nevada and find out like, do you think this is a good law? Do you think this law applied in this way would be just? I think that's a little bit unreasonable. Ultimately, you want a knowable law, you're going to have rule of law at all. But wait, there's more to the idea of rule of law, and James about this too. Equality. We believe that like cases should be treated in a like manner. This is why we don't just have some like no law, and just like every time somebody thinks somebody did something bad, we bring them before some wise old man, like King Solomon or like Greg Wilson or somebody like that. And say, like, do you think this guy was bad or not? The whole point of the law is that you can know it and that people who do the same thing are treated the same way. There's some equality before the law, and the very notion of equality before the law is horribly undermined in their study. So the fourth and final thing Jay talks about is like it's bad, you have like this BS defense that everybody can try, but that like rich lawyers in particular. So Jay talks about like a better lawyer like matters more in oral hearing litigation. The response we get is nuh-uh. What am I supposed to say? Think about it, right? Like some public defender isn't going to make a very, very compelling case about like this like sodomy laws in general are unjust, right? You need, insert your favorite debater here, right? Like Peter Gerges, like Adam Zirkin, right? Like getting all red, walking out in front of the podium, getting close to the jury box, and like telling you about like the horrible injustice that happening in economic gravity. Ultimately, you just don't get that from a public defender. You only get that from the Harvard Law School grad. The other day, some more cases will go to trial. They say, well, if you beat up a woman for her welfare check, you're not going to go to attempt nullification. Like, think about it. A huge percentage of like the crimes that are committed are like drug-related crimes. The very first drug example, every drug crime is going to go to trial. That means you have an increase in the number of trials that occur by 500%. The system just isn't equipped to handle that. And if you think public defenders are overworked now, they're going to get a whole hell of a lot more overworked. At the moment, they're constantly showing up in courtrooms and constantly giving like a canned speech, which I saw Adam Zirkin give once, about how drug laws are bullshit.
So it's really unjust to have these drug laws in the first place. Isn't it better to have all of the trials like happening so that individuals can be like, this law is unjust, and then get off instead of like arguing being sent to jail?
Okay, I'm just not sure that drug laws are unjust. Maybe many of us think drug laws are unjust. I know Chris Kelly thinks that drug laws are unjust. Like in general, we have to recognize that we'd rather live in a society where the majority gets to determine what is and is not just. If we care about like protecting women and protecting black people and stuff like that, than what like one random person thinks. Because all it takes is one guy on the jury not to agree with the law for it to be impossible to enforce that law. This can make it very difficult to enforce any law that any significant segment of the population disagrees with. That's a tremendous problem. So let's start the case. We say that, look, nullification might happen to some extent no matter what. There's no reason to encourage it. Like, rape will happen no matter what. We shouldn't tell people that, like, hey, like, rape is an option available to you. So they say that some laws are unevenly enforced, right? And then they say, well, like, it's worse for this law to remain on the books. This is like just a point for opposition, right? When a jury nullifies, the law remains on the books. When the appeal court says this is unjust, the law is struck down, it gets changed, or it's removed from the books entirely. So if you believe it's important to take unjust laws off the books, they get taken off the books on our side of the house. Then they say this is a transfer of the judge's power. We agree, that's bad. The reason we have a judge and a jury is that they're supposed to be different things. Juries deciding questions of fact. That's hunky-dory, they should retain that power. Judges deciding questions of law. Questions of law are complicated. I don't understand them, and I debate a lot. Most people don't understand them. Judges do understand them. That's why they go to law school. That's why they pass the bars. The final thing they talk about is only educated people. This is another classic optimistic, right? Assume that poor people are like phenomenally stupid. You don't need a college degree to consider the possibility that if somebody being prosecuted and you think it's total bullshit, you can find him not guilty, right? This isn't like little second incompleteness theorem for second order. It's just not that hard. I just think most people have figured out this concept in some way. So the second thing they talk about is citizens in a democracy, right? They talk about civil disobedience. I think the very notion of civil disobedience is like you harm yourself to protest the law. I think that's very different than like letting a crack dealer out on the street because you don't like the crack laws. I think it's one thing to say I'm willing to sacrifice myself because I disagree with this. Another thing to say I'm willing to sacrifice the safety of some other community. It's not like the safety of a housing project where I don't live that's a couple miles from my house because I don't like drug laws. So then they talk about like the formation of the rule of law is not representational. It's a hell of a lot more representational than 12 people chosen at random, right? I agree that if we live in just a dictatorship, this would be okay, but we don't. So they finally say we should really disapprove. This doesn't provide knowledge. Juries don't state a reason for their decisions, so nothing's given. So the final thing they talk about is fair trial. And I think this is active liberalism at its worst. Because this goes both ways. It's unfair when somebody goes to jail for a BS law. But you know what's also unfair? It's unfair when some mammy-pammy liberal type lets a crack dealer out of the street because he thinks drug laws are bad, and people in a poor neighborhood with that mammy-pammy
bad law is unequal enforcement. We think generally any system of law that just treats like cases differently can't possibly be a just system of law. They don't provide you any reason to believe why two different, randomly selected groups of 12 people will make the same decision in similar cases. For the most part, they won't, especially since just having one person on a jury who doesn't believe that a law should be enforced is enough to get a hung jury and enough to get that person not convicted. We think in most cases it's going to be almost impossible to apply any law that anyone in society disagrees with, which is most of the law. They want to talk about a different kind of unequal enforcement. They say, well, things like sodomy laws are enforced unfairly. But you can sue directly for this kind of unequal enforcement, and that's why the Supreme Court right now is hearing a challenge to Bowers versus Harvey, and it's probably going to overturn sodomy laws. A second kind of terrible law that side government creates is law that you can't know. The law books can say X, but that might not matter in these cases, because a group of 12 people might decide that the fact that the law book says X doesn't really matter. That law is bad, and we're going to have to put it into our conscience. Law that's unknowable can't possibly be good law government. The third kind of bad law that I want to talk about, I think we can all agree on this, is law that allows people who beat their wives or lynch black people and still get off probably isn't good law. And there's a system in any case where there's any considerable portion of the population that believes, no matter how wrong we think those things are, they believe they're okay and they believe they're willing to let people like them off. And that creates a system with those laws that society as a whole decided immediately to protect the rights of minority groups in society just can't be applied. The second major thing I want to talk about then is comparing appeals with nullification. I think there are a number of significant benefits of using the appeals process. Appeals may take more time. I think this is a necessary concept. First of all, you get laws off the books. If laws just aren't applied, if in some cases people nullify, that's one less appeal that could happen. That's one less chance to actually get the law off of the books for everyone, rather than just still having the law sitting there, and still having people who don't have lawyers that are good enough to argue for nullification being prosecuted under that law. Appeals courts can do things like look at statistics about how a law is applied. The Department of Justice can consider this entirely in context and make more objective decisions and actually take these laws off the books. Just to tell you that lawyers get more. The public defender X, who's defending the average person accused of a drug crime in the United States, isn't going to be able to make a particularly compelling nullification argument. The point where most of those arguments depend entirely on rhetoric and not at all on appeal to direct knowledge of specific cases, codes, and laws. As a result, we think Johnny Cochran's going to be able to get his rich client off on this kind of nullification standard, but the average person won't. We also tell you that judges actually know the law. Juries act as fact finders, and they do so within a clear legal framework that's explained. Kate tells you that the bad law standard is just as clear as this legal framework, but it just isn't. A bad law, but what is a bad law, is entirely subjective. We think juries can determine facts, but they can't make these kinds of purely subjective determinations. Moreover, juries don't actually have to give reasons for their decision. Juries don't have to write briefs the way appeals courts do. So you're not even going to have this kind of precedent on the books anymore. The last thing I want to talk about is the numbers. Kate tells you something else, right? She says, the law ought to follow along with what we believe to be just. I think this is true, but we doesn't mean 12 people. We doesn't mean the people in this room. We mean this country at large. And as long as we can vote for legislatures, we think that democracy as a whole is going to work. We think the government as a whole is going to represent, generally, what people believe. They say 12 people is going to be representative, but it isn't. I don't think a group of randomly selected 12 people from Mississippi are necessarily going to respect the best interests of this country, and I don't think they should be allowed to. I'm sure many samples of 12 people in Wyoming would have let Matthew Shepard's killers go, and we don't think those people should be given that option under the law. You can simply disobey a law. You can try to get that law changed. But if you simply disobey a law and break that law, then you're still going to jail as a cost for taking that kind of action. We think as long as the law exists, the law ought to be followed. Yale and Kate think they know what justice is. But at the point where the government isn't imposing laws, the majority of the people are. We think the majority of people ought to be making the decision of whether a law is unjust or not.
Trials are about one person. Trials are not about society. Trials are not about how society is going to benefit. It's not about how society is going to better progress. Trials are about making sure that that one individual on trial, that one defendant, defendant has all of his individual rights protected. Because we don't believe that a courtroom, we don't believe that trials ought to be utilitarian. We don't believe that trials ought to take everybody's interest into account. The only interest that needs to be taken into account in a courtroom, and with the judge, and with 12 jurors and more peers, are whether or not that individual is being justly tried. At the point at which that individual is not, at the point at which that individual is being put into jail because of a sham law, because he's being put into jail because a law is applied only to black people, or only to poor people, that's not fair. And that's not something that we should tolerate in a liberal democracy. That's something that's important to a liberal democracy, and I don't understand why side opposition doesn't understand this. Individuals in a trial have an obligation, and society owes them an obligation to care about them first and society second. That's the only thing that matters, and that's something that they draw from their side of the house. They say, well, what about the law? You'll get the law off the books with an appeals. Yeah, you will, we can see that. But the problem is, that happens 12 years down the road. That happens when somebody who was put into jail because of a sham conviction, because of an unjust law, was put there because of the fact that the law was unjust, and now he has to have 12 years of his liberty taken away because we're using him as a pawn to our social ends. That's not fair. That's not what justice is. And I think if that's the definition that is chosen to defend that throughout today's round, that's a sham definition of what we actually believe justice is in a society. That being said, I have three things I want to talk about. I want to talk about defendants, I want to talk about society, and I want to talk about the rights in the law. So, what do defendants have the right to? Defendants have the right to the best defense possible. They want to paint trial lawyers as these really shady individuals. They want to paint trial lawyers as people who give rhymes in court and let OJ off. But trial lawyers are people who we respect to actually defend an individual and to make sure that his rights are not violated. Sure, trial lawyers might be slimy sometimes. But at the point at which they say on that side of the house, you don't want to give trial lawyers any more rights, that's an argument to take away a reason of mental insanity by temporary insanity. That's a reason to take away a defense of reason by duress. Why? Because those are all examples of a certain thing of an affirmative defense. If you think that a lawyer is too important, that's just what's going to happen.
You're saying you should take away other privileges that lawyers now have and new responsibilities.
Yeah. Look, lawyers already have rights in the courtroom, and we believe that lawyers should have options to exercise those rights. Lawyers should be able to defend their clients as well as possible. And just because they might be a little bit better, just because they might have a little bit of an advantage, doesn't give us a right to take away that right from individuals in society so that they won't be convicted of an unjust law. They won't be convicted of an unjust application of the law. I would tell you that defendants have a right for equal treatment. Look, people don't know. People don't know about jury nullification. If they did, we wouldn't have different sentencing for crack and cocaine violations, but we do all the time. That's an example of the fact that jurors don't know about this. But at the point at which jurors don't know about this, we have an obligation to tell jurors, this is a possibility for you to actually exercise. This is what you can actually believe. And they want you to believe that 12 people in Crown Heights are going to know exactly the same thing as the 12 people in Westchester. They can run that off. It's not a very good one, however. The fact is that those people don't know the same thing. Those people don't know the same thing as the people who actually have an education. And so what that means is that people who committed a crime in a rich area are more likely to get off because of nullification than people who committed a crime in a poor area. And it's a travesty of justice. They tell you about the fact that minorities get hurt. They talk about the lynching problems. Look, those people get off all the time. People who were lynching people in the South got off, not because of jury nullification. They got off because the society was going to take them off alone, regardless of whether or not they actually committed a crime. The question of nullification has nothing to do with that. The fact that the society was just flat out racist is what's going to do it. And that's not solid on either side, and that's not an argument that they can polish on that side of the house. The final right that defendants have is not to be a pawn of society. Defendants have a right to their own trial, and their own trial is something that's important in today's round. They have a right not to be the pawn of society for a greater social ends, and I don't think we ever hear an adequate response from JT. The second thing I want to talk about is society. Because one of the main points that we give you throughout this round is the idea of transparency. That individuals in society, and the government as a whole, should have knowledge of what individuals in society think about the laws that are on the books, and the way that those laws are actually applied to individuals. Look, sure, I mean, jurors will have to tell the court, we find this person not guilty by reason of nullification, right? When a lawyer says, I find him, or we're not guilty by reason of nullification, and you find him not guilty, that's a pretty clear message to society that we find this law unjust. So that argument that they give you holds no weight. Now, society has a right to be involved in the process. This is why we trust juries to send people away. This is why we trust juries to hold the fate of individuals in their hands. We trust juries, we should trust them to recognize whether or not we should send somebody away because of the fact that a law was unjust. We don't want tyranny of a majority in society, and that's what happens when you have laws that are not representational, when you have laws that are not being put on the books by the people who should be putting them on the books. But the final thing I want to talk about is our rights under the law. Because they want us to believe that we vote, and because we vote, the law is representational, but it's not. The law isn't representative. The fact is that the religious right has an unbelievable amount of influence in our society, and they're oftentimes the ones who decide on laws. The fact is that special interest groups are possibly the people who decide on laws. It's not actually individuals in society. And so when it's those people who are deciding on laws, it is a moral obligation placed upon the jurors in that juror box to decide that we're the ones who need to be in check. We're the ones who are representational and representative of society. We're the 12 people who are the last defense against this guy going to jail because that law was unjustified. Opposition philosophy throughout this round has been necessary costs. There are just some necessary costs that people have to bear. That's not fair, and that's not an aspect of justice that I'm willing to embody. For all those reasons, Kate and I are for counting costs.